Please get ready for a dictation of exercise 25 from January 2019 issue of Progressive magazine. 5 seconds. Start. Thereafter, on January 16, 2006, the Indian company issued payment instructions to HSBC Bank, Dubai, for an amount of rupees 16 crores to be deposited in the account of the defendant number 1 in Andhra Bank, Chennai. According to the plaintiffs, contribution was towards equity share capital held by defendant numbers 3 and 4. Share certificates were also issued and recorded as having beneficial interest by the ETA Group. Later, on March 6, 2006, the Indian company received further investment through 4 demand drafts amounting to rupees 3 lakhs from defendant number 12, which was recorded as beneficial interest of the defendant number 2. Defendant number 11 is in possession of these shares as well. It has been further stated that between December 2005 and March 2006, a total sum of rupees 16 crores had been received by the Indian company from defendant numbers 12 and 2 towards issue allotment of shares. On June 25, 2009, defendant number 3 issued a personal check of rupees 2 crores which was honored on July 7, 2009 in the accounts of defendant number 2 and reflected that the investment was made in the Indian company. On June 28, 2009, a further investment was made in the Indian company by defendant number 12 to the tune of rupees 2 crores through payment instructions to Emirates Bank to debit the same, which was actually credited on July 1, 2009. In 2011, 2 investments were made on December 26, 2011 to the tune of rupees 18 crores by payment instructions to Bank of Baroda, debiting the account of defendant number 12 and crediting the account of the Indian company. Thereafter, share certificates in the names of the defendant numbers 3 and 4 were issued by the defendant number 1 around February 10, 2012. The plaintiffs also stated that defendant numbers 3 and 7 admitted and acknowledged that defendant number 2 had a beneficial interest in the share certificates of the India company issued in their names. Defendant numbers 3 to 7, however, do not have physical possession of these 2,70,000 shares, the same being held by defendant number 11. It was also contended in the plaint that defendant blank had share transfer forms of the company. Accordingly, it was urged that defendant number 2 has a beneficial interest over the shares of the defendant number 1 but held in the names of defendant numbers 3 to 7. It was further urged in the plaint that deconsolidation of the accounts and businesses of defendant number 2 with that of defendant number 11 was effected in 2016 with retrospective effect from 2014. The same was on account of defendant numbers 3, 4 and 7 to sign the financial statements of defendant number 2. It was also urged that till the time the Indian company had requirements for funds, the interest of defendant number 2 was acknowledged and it was stopped subsequently. It was further urged that the entire remittance towards the suit shares of 6.16% of the Indian company were by the funds provided by defendant number 12 or defendant number 2, and no part of the funds came from the personal accounts of defendant numbers 3 to 7. It was further urged by the plaintiffs that defendant numbers 8 to 10 had direct knowledge of these facts. It is pertinent to mention here that there is no dispute regarding the fact that the decision of the Board of Directors of the Group General Body, followed by defendant number 11, through the draft financial statement, would impact the financial interest of defendant number 2 in the shares held by in the name of defendant numbers 3 to 7, which was the subject matter of the suit. Plaintiff number 2, under these circumstances, wrote the letter dated June 1, 2017 to defendant number 8, the managing director of the Indian company, protesting that the investments made by the defendant number 2 were denied. Defendant number 1, through its letter dated June 7, 2017, refused to take notice of the claim asserted by the ETA group. Plaintiff number 2 thereafter sent another letter dated June 12, 2017 to the Indian company, addressed to the managing director of the Indian company, giving details in support of the claim of the ETA group. He also called for a meeting in person. However, defendant numbers 8 and 9, along with other directors of the Indian company, failed to attend the meeting proposed by plaintiff number 2. However, they sent a letter dated June 27, 2017, stating that they had earlier replied on June 7, 2017 itself and had nothing further to state. Plaintiff number 2 sent another letter dated July 9, 2017, reiterating his original stand. The Indian company responded through the letter, "Stop.